Exactly. Welcome. We're going to go ahead and start, y'all. And I really want to thank you, Judge Gibbons and Mr. Duff. Thank you for being here today. Unfortunately, we're having votes called right now, and if somebody could tell me how many. We're going to have 3 votes. And so Joe and I will do our opening statements, and we'll do our best to see if we can get through at least one of yours. So thank you very much. First, let me make a comment about, on behalf of the subcommittee, expressing our deep condolences over the death of Judge Roll. What a terrible, terrible tragedy, and he served Arizona and our nation so well. And I know that the loss of him is truly felt throughout the judicial system, and in a very, very sad situation, but it is something that we take very seriously, and certainly we hold him, his family and friends, and our thoughts and prayers, along with all of the rest of the victims of the senseless shooting in Tucson. An independent judiciary that holds the trust and respect of all of our citizens and can resolve criminal, civil, and bankruptcy disputes in a fair and expeditious manner is fundamental to our nation. In addition, the judiciary's probation and pre-trial service officers perform a critical public safety mission by supervising more than 200,000 offenders and defendants living in our communities. We'll do our best to ensure that y'all have the resources needed to accomplish your important mission, especially since your criminal, bankruptcy, and probation workload is growing. However, something I have to say to everybody who comes before our subcommittee with a $14 trillion debt, it does compel us to reduce spending, and I'm going to be committed to reducing spending substantially throughout this budget process. The judiciary's budget request proposes a discretionary spending increase of $424 million, or 6.6% above the fiscal year 2010 level. This is more than the subcommittee and the nation can afford right now, y'all. So I want to work with you. I want to work very closely with our ranking member and my good friend Joe Serrano to identify savings in the federal judiciary's costs while still providing the courts with the resources needed to fulfill your constitutional duties. I appreciate the important work that you do and look forward to your testimonies. And now let me recognize my very dear friend, Joe Serrano.
Thank you so much, Madam Chair. I'd like to associate myself with the Chair's remarks regarding Judge Roll. By all accounts, he was an outstanding jurist, caring husband and a father, and an active member of the Tucson community. And his tragic loss is felt by all of us, and we mean that sincerely. And please pass along, again, our heartfelt condolences to his family and to his colleagues. I'd also like to join with the Chair in once again welcoming Judge Julia Gibbons and Director James Duff to the subcommittee. They have been here several times before, and they're going to keep doing it till they get it right. No, that's an old joke. I can't help myself. And I've always done a wonderful job of addressing our many questions. Yesterday, we heard testimony from the General Services Administration, which for the second year in a row has not included any funding for new courthouse construction. It will be interesting to contrast the answers we heard from the GSA on this issue with any further information that you provide today. I suspect that there may be differences in the priorities of the federal judiciary and that of the GSA, but I'm sure we'll get a chance to hear more about that. Additionally, and I mentioned this at every hearing, I believe that there is an important questions we in Congress need to ask in order to understand the impact of a government shutdown on the third branch. For instance, if there is a government shutdown, what limitations are placed on judges? Will access to the court system be restricted? It would be extremely troubling if a government shutdown doesn't just limit access to the executive branch, but to our federal judicial system as well. The federal judiciary plays a crucial role in our democratic system, and we must make certain that you have all the resources you need to ensure our federal justice system continues to set an example for the rest of the world. And I look forward to your testimony and welcome you again. And apologize for the fact that we're interrupted, but that's part of our job to vote. You know.
Judge Gibbons, I'd now like to recognize you, and if you'd be so kind as to keep your remarks to 5 minutes or less, we'll have more time for questions.
And members of the committee, I'm Judge Julia Gibbons of the Sixth Circuit Court of Appeals and Chair of the Judicial Conference Committee on the Budget. As you know, with me today is Jim Duff, Director of the Administrative Office of the Courts. I thank you both for your remarks about Judge Rowe. He was a fine judge and a fine man, and I use those terms in the way my mother would have used them, to mean the highest of compliments. There's a special poignancy to the way in which he died as we are here today together, because he died trying to nurture the relationship between our two branches of government in speaking to his friend, Congresswoman Giffords. I begin today by expressing our deep concern about the impact on the judiciary of various proposals offered by some members of Congress to shrink the size of the federal government through deep spending cuts. We've seen proposals to reduce spending to FY08 levels and to FY06 levels even. Such a budget-cutting approach may prove effective in some areas of federal spending, but it would have a devastating impact on the federal courts and the administration of justice. Unlike many executive branch agencies, we do not have programs that we can cut in response to a budget shortfall. So deep funding cuts would not reduce the scope or volume of our work unless Congress also makes dramatic reductions in law enforcement programs. We do not have the discretion to decline or defer cases based on resource constraints. In fact, the opposite's true. We're required to adjudicate the cases that are brought to us, regardless of staffing and resource levels in the courts. Through new laws enacted and resources provided for law enforcement programs, Congress determines the jurisdiction and, to a large extent, the workload of the federal courts. The President's policies carried out through the Department of Justice also play a role in our workload. Hundreds of new federal laws have been enacted over the last 30 years that have significantly increased our jurisdiction. In turn, we've seen rapid workload growth, and our workload currently is at or near record levels in most filing categories. With this increase in workload in mind, I respectfully ask you to consider the March 18 letter from Chief Justice Roberts, in which he asked Congress to provide a total FY 2011 appropriation to the judiciary of $6.92 billion, which is slightly above the 2010 appropriation. This is the amount needed to maintain our current staffing levels and provides no additional court staff to meet growing workload needs. Turning to the details of our 12 requests, we seek $7.3 billion in appropriations, which we have described as a 4.3% overall increase above the FY 2011 assumed appropriations level. In the absence of a final appropriation, we assume the funding level included in the full-year CR passed by the House in December 2010. The 6.6% figure used by Chairwoman Emerson is the 2012 increase over the 2010 enacted level. We listened carefully and we heard what you said about being unable to afford 6.6%, and I think you know that while we have a history of requesting what we think we need for the courts to fund the growing workload, we also have a history of working with the subcommittee in recognizing what is possible. Of the requests before you, $258 million, or 86% of the increase, is for standard pay and non-pay inflationary adjustments and for adjustments to base reflecting increases in our space, information technology, defender services, and court security programs. The remaining $41 million is for new court support staff positions, largely in probation and pretrial services offices and in bankruptcy clerks' offices, program improvements in our IT program, 4 new magistrate judges, and several smaller program enhancements. We are subject to the 2011 and 12 freeze on federal pay, so our request does not include a cost of living adjustment for judges or staff. Our request reflects our ongoing efforts to contain cost. We are in our 7th year of an intensive effort to reduce costs throughout the judiciary, and our cost containment program is producing results. We have achieved the most significant cost savings to date in our space and facilities program, and GSA has been very cooperative with us in this area. My written statement includes more detail about cost containment, which continues to be a top priority for us. I ask that my entire statement be placed in the record along with those referenced in my written statement, and I'll, of course, be happy to answer questions.
Without objection, Judge Gibbons. I think, if you all don't mind, let's take a brief recess while we go vote. We've got the 3 votes, and then we'll begin again with Director Duff and then questions. So thank you all, and I apologize.
Thank you.
We're at your disposal. We're appreciative of the opportunity to be here.
Okay, sorry, y'all. Director Duff, we'd love to hear from you, and if you could keep your remarks to under 5 minutes or close to, then we can spend more time on the questions. Thank you.
Thank you. Good afternoon, Chairwoman Emerson, Representative Serrano, and members of the subcommittee. I am Jim Duff, the Director of the Administrative Office of the U.S. Courts, and it is a pleasure to appear before you today. I also want to thank you both for expressing your condolences concerning the death of Judge John Roll. We will certainly pass them along to his family. He was a hero and will be greatly missed. Since 1939, the Administrative Office of the U.S. Courts has provided a broad range of support to the federal courts nationwide. We've evolved over the years to meet the changing needs of the judicial branch, but service to the courts has been and remains our basic mission. For fiscal year 2012, we're seeking an appropriation of $88.5 million for the Administrative Office of the Courts. The requested increase is primarily made up of base adjustments to maintain current operations. As Judge Gibbons noted earlier, however, this budget request was developed last fall based on assumptions at that time. And once we receive the final fiscal year 2011 appropriation, we will update our fiscal year 2012 request and provide that to the committee. The fiscal year 2012 request also includes funding for the same 3 new positions to address high priority program requirements that are critical to the operations of the courts that were requested in the fiscal year 2011 request. Specifically, 2 of the positions support a comprehensive modernization and consolidation of the judiciary's nationwide accounting system. It's a multi-year effort that will provide the judiciary with significant improvements in its accounting of appropriated funds. The 3rd position is requested to support an initiative to address judges' internet security concerns, including internet threats and the availability of judges' personal information on the internet. This request, also originally in the FY 2011 budget request, was the first request that we've made to fund additional staff from the AO's appropriation in 6 and now 7 years. As I've said before the subcommittee, that I implemented a hiring freeze when I joined the Administrative Office of the Courts, a freeze for a couple of years. So we've not requested positions for now 7 years. Before I close, let me, with these opening remarks, let me mention briefly something Congressman Serrano mentioned, and that is funding for courthouse construction. For the 2nd year in a row, the President's budget for General Services Administration does not request funding for new courthouse construction projects that reflect the priorities of the 3rd branch, as detailed in the Judicial Conference's 5-year courthouse construction plan. For 2012, the Judiciary's courthouse priorities are Los Angeles, California, Mobile, Alabama, Nashville, Tennessee, Savannah, Georgia, and San Jose, California. Each one of these is critically needed to address major operational deficiencies at those locations. And I would like to include our 5-year plan in the official record. I urge the subcommittee to consider the priorities of the Judicial Conference with regard to courthouse construction projects and include funding in your 2012 bill for the 5 projects I just mentioned. That concludes my oral remarks. I'd be happy to answer questions and would like the full statement submitted for the record.
Thank you very much, and without objection, your full statement will be entered into the record.
Thank you.
So we're talking about the budget and the need to address our country's unsustainable debt. And as I've said earlier, we're going to have to reduce spending of our subcommittee and have been asked to try to reduce it to 2008 levels. But I must say, since 2008, the court's workload has increased significantly in many areas, such as criminal and bankruptcy filings and supervision of offenders and defendants living in our community. So I imagine it would be somewhat difficult for the judiciary to reduce its funding to 2008 levels. with that said, could you all describe to me the impact on the judiciary if we did reduce y'all to fiscal '08 levels? Judge Gibbons?
Well, as you have referenced, this would be a very, very, very difficult situation for us. A hard freeze at the '08 level for 2012 would require a reduction in current onboard staffing levels as of February 13 of this year of 7,872 positions, or 3,936 FTE. And you'll recall that we have in total, the judiciary has about 31,000 employees, and 22,000 of those are in clerks' offices and probation and pretrial services offices. And historically, the cuts have been taken, any cuts have been taken from among that 22,000, the remaining being judges and judges' personal staffs. Funding for the courts would be 18.9% below the 2012 budget request level. We would see serious and long-lasting problems for the courts in terms of supervision of convicted felons who are released from prison, delays in case processing, and that has different impacts depending on what kinds of cases we're delaying. Obviously, if we're talking about bankruptcy cases, we're talking about sometimes an economic impact. If we're talking about criminal cases, we're talking about potentially having to dismiss indictments under the Speedy Trial Act if we cannot get those cases handled in a timely fashion. In civil cases, we're talking about serious hardship to individuals and businesses if they cannot get their disputes timely resolved. We're talking about a decline in service, reduction in the hours that clerks' offices are open, delays in improvements to our automation program, such as the updates to CMECF that we need to do, and in the court security area, there would be another very significant impact. We would have to eliminate 73% of our request for security systems and equipment. We would cut approximately, or lose approximately 685 court security officer positions, or 16% of the current positions. And those are a few of the, to give you a little bit of the feel for both the statistical side and the policy impact side, it would be a very serious situation for us and for the public whom we serve.
Well, I appreciate that, I really do. But let me also say that 2012 levels are probably not feasible as well.
We understand that.
And so, it is interesting when you hear people come in, usually, people would say, could we just have a marginal increase? And I've noticed that this year it's flat funding is people are happy with. But what would happen? What would happen with you all, or could you sustain a 2010 level?
Well, better. Let me just point out for one thing in one figure I gave you was not dependent on 2012 levels, but the first figure, the employee figure, the 7,000 plus positions, was based on onboard staffing levels, not 12 request levels. Here's what we look like in 2010 for 2012. About 552 positions, again, measured below current onboard staffing. The suspension of panel attorney payments for about 15 weeks. And of course, that's all dependent on what might happen with respect to whether we would have to delay panel attorney payments in 2011. Again, eliminating 73% of security equipment requests, 168 CSO positions, we feel. And, you know, some of the same impacts that I described from a policy standpoint, but again, obviously to a lesser extent.
Right, okay. Well, and, you know, the Bowles-Simpson Commission proposed significant reduction in travel and printing and vehicle budgets. And so what are y'all doing to save money in those areas?
Okay. We spent about $111.7 million on travel in 2010, or 1.6 of total judiciary obligations. We spent $18.7 million on printing and reproduction. A lot of our travel is case-related. That is supervision travel by probation and pretrial services officers, going to the homes of offenders to determine the extent to which they're complying. And then we also have judges and, to some extent, their staffs who have to travel to various places of holding court that may not be the residence of the judge. We have tried already to impose some limits on staff travel with judges for holding court, and we monitor very carefully the supervision-related travel. We have increased the use of video conferencing, and we've used various methods for training that do not require physically coming to the location. We've held our any national meetings at central locations that can be more economically reached. But I think that we can make some more modest improvements in this area.
Well, you know, I know in the Eastern Division of Missouri, for example, we've got judges coming down to the Southern District Courthouse, and then the Southern District Courthouse judge going up to the St. Louis, and so there's a lot of expense back and forth, and sometimes what happens is that they perhaps will do the trial down in one spot, and then they'll do the sentencing back up in St. Louis, which is over 100 miles, and then not only do you have the expense of the judge and the staff, but then there's that ripple effect upon the marshal service, taking the prisoners up, I mean, and back and forth. I mean, and I do think that in some cases you can, I mean, realizing that you don't have to pay the marshal bill, but it still adds up in the whole cost of doing business, that there can be some more thought given to saving money just with regard to that kind of travel, because, you know, for one judge it could be $10,000 a year, $20,000 a year, and then it starts adding up once it's, you know, 10 here, 20 there, start talking about real money.
You know, courts that have more than one place of holding court have to face and decide how they're going to allocate the cases, and it's a decision that statutorily is made by each court, and typically the court tries to value random assignment, which is judicial conference policy, but the courts take other things into account too, such as geography and convenience, and it may be that in this era travel cost will become something that courts should become more cognizant of as they work on how they're going to handle their cases.
Yeah, and perhaps it's one of those easy things to fix, or easier things to fix. And certainly I would rather save money on that side of things as opposed to having to furlough or lay off staff, so that you can, you know, you can get your jobs done. There's more than one way to skin the cat here. Let me ask you, and then I'll yield to my colleague, Mr. Serrano. How are you all in the judiciary using automation to reduce staffing levels in district bankruptcy and appellate courts?
Well, you know, I can't point to, I can't tell you X project has saved us X amount of staff cost, but we have become very fully automated, and this has produced very significant savings for us. Our case management, electronic case filing system has produced savings in docketing and just the way we used to handle paper, which was pretty labor intensive. We have made just great advances in the way probation officers receive the information they receive to supervise defendants. And this really helps them in terms of having better information, but it's also enabled probation and pretrial services offices to dramatically reduce their support staff. Jim referred to the new judiciary financial management system, which is going to consolidate the accounting that is now carried out in 94 districts, so we'll be doing it on a national basis. There are just many, many things that we have done, and I can't quantify it for you, but I think that we have, I think we've really done a good job within the judiciary. And going forward, you know, if there's several other major projects we're working on that I could describe for you, but I think we've done well. You know, I didn't mention when we asked about printing costs, I didn't mention the extent to which our electronic noticing and the electronic filing, the extent to which that's saved on printing cost. I mean, that's another kind of saving we've seen.
Well, and thank you for that. Mr. Duff, do you have anything to
Well, I
add?
was just going to add that a lot of it's cost avoidance. There are savings, but and we can attempt to quantify that. But
Yeah, I mean, it just, we're practicing a lot of medicine telephonically these days, so anyway. Thank you. Mr. Serrano?
Thank you so much, and thank you for your testimony. Around here in Congress these days, things are getting a little confusing. The last time we enacted a bill was for 2010. We're working on 2011 now with H.R. 1 sitting out there. But yesterday, we got the proposal from the majority party for 2012. So you have to keep up with the numbers, otherwise you could pass the wrong bill and we could be 2 years into the future or something, or back. So my question still is, how does H.R. 1, and at the end of the day, we don't know what's going to happen. Right now, we got a message saying that things are getting closer, and, you know, the Speaker and the leader in the Senate are getting closer. But everything could fall apart, and H.R. 1 may be eventually the tool. So speaking about H.R. 1, how would it affect you? What would have to happen? How many people you would have to let go if you have to let go people? How would it affect the caseload? Assume for a second that it's H.R. 1.
Well, H.R. 1's not a good result for us either. It's $143 million below of FY 2010 hard freeze level, and the impact on the courts would be very significant. We would be affected in the various ways that I described for Chairwoman Emerson with respect to a hard freeze at 8 levels for 12. But in terms of numbers, it's a little hard to say what the numbers would be, because we would have to make some decisions about how to manage it. We have said we could lose up to 10% of our current on-board workforce in probation and pretrial services offices and clerks' offices. That's 10% of that 22,000 or so I talked about earlier. But we're a little careful in using that because we, for example, might decide that we wanted to furlough more people in order to terminate fewer people. So there, you know, so in order to say that it's an absolute loss, I think would be, we would not want to, I guess we wouldn't want to spread alarm in that way at this point. And nevertheless, that's the figure we're working with, although there would be decisions made as to how to manage the cut. We would have to stop payments to CJA attorneys, we think, for about 5 weeks of the fiscal year. That causes some real problems for us, not just because we're not paying the lawyers for work they've already done, and because many of them are sole practitioners and those in small firms who really depend on the income, but also it affects their willingness to seek appointment in the future. So that would be a very serious outcome for us.
And you'd have to furlough people?
Pardon me?
You'd have to let people go?
You mean employees?
Yes.
It would be very hard for me to see how we could avoid that.
Do you know how many?
Well, as I said, we're using a figure of 10%, which would be roughly 2,200.
Right.
But there's terminating, and then there's things like buyouts, and there are things like furloughs, and the executive committee of the Judicial Conference would have to figure out exactly how we were going to handle reductions at that level, but it would be very serious, and I would not anticipate that we could handle it without the loss of significant numbers of employees.
So you're saying at least 2,200 could be affected? Using the number, I know everything is in flux. These are not
I think
numbers.
I think affected, yes. Whether those people will all outright lose their jobs, I'm not sure. I'm not sure.
Mr. Dunn?
I agree, and a lot of those decisions will occur at the local court level as to how they go about it, but those overall figures and numbers are what we're facing, probably.
Right. On March 18th, Chief Justice Roberts sent a letter to Congress regarding FY 2011 for the federal judiciary. In his letter, the Chief Justice appeals for a funding level of $6.92 billion for the judiciary. Could you discuss the funding level requested and what it will allow you to accomplish in 2011? Of course, half of 2011 is gone already, right?
The figure selected by the Chief Justice is $75 million above a hard freeze at 2010 levels. And what that enables us to do, and what it would enable the Congress to do, actually, is avoid deferring Criminal Justice Act panel attorney payments during the year, because if you defer payments during any part of 11, of course, you've created a problem for 12, because those attorneys, you're going to be paying back into 11 obligations out of 12 funds. And it would also give us a small amount of money for security systems and equipment that are critically needed, and it would enable us to maintain current onboard staff. So it's $75 million above 2010 hard freeze. It would enable us to maintain current staff, not have to defer payment of CJA attorneys, and buy some much-needed security equipment.
This funding, obviously all funding affects workload. So how has funding and staffing kept up with workload for the past, say, 10 years?
With your help, we think we've kept things fairly. We've kept fairly apace over the last several years. That contrast, when I first became chair of the Budget Committee, one of the big points we used in advocating our budget request was that our funding and our staffing had not kept up with our workload, but we appreciate very much the help you have given us in reaching a better place with respect to a correspondence between funding and workload.
The one, I agree, and thank you for the great support we've been getting. The one area where we could use additional help along the way, and in the past 10 years, have been judgeships, and particularly in areas of the country that are very overworked, border courts, for example, where we need additional judges, frankly, to handle it. And we've been shifting and doing inter-circuit assignments to help ease the burden in those courts, but that's the only one area I would mention.
You know, as I listen to you, I have a thought. You know, Madam Chair, this morning the CJS Frank Wolf Committee with Mr. Fattah had the FBI director there. We were talking about the increases they've received over the years. And I know that there is a strong desire, and we've discussed this, you and I, both personally and publicly, to cut, and I understand the whole issue. But I think what a lot of people miss is that some of those increases over the last 10 years, or to be exact, since September 11th, were related to a crisis that this country was going through. So yes, if you look at Homeland Security as an entity, through the roof. Not necessary? Of course necessary. If you look at, for instance, security alone for federal judges, and it obviously, unfortunately, doesn't work all the time, otherwise we wouldn't have made the statements we made of condolences, but the security at the courthouses have gone up. And so much of that, the FBI received amounts of money that people would be upset about, but they were shifted, if you will, from following white-collar criminals and so on to following terrorists all over the world. And I think in the deliberations of how we got into all this, you know, debt, if you will, no one takes into consideration that we were involved in 3 wars. One in Iraq, one in Afghanistan, and one at home, trying to protect ourselves. And that doesn't seem to play anywhere, that a lot of that money was spent on that.
Those are good points.
Anyway.
And with regard to the courts in particular, a lot of the money, another area is the money spent on immigration enforcement, which of course has had a huge impact on our needs along the southwest border in particular.
Thank you, Madam.
Thanks. And I don't disagree with you about all of the added security costs. And the need, I mean, and then speaking just of the southwest border, I understand that nearly 40% of the felony defendants are processed in the 5 districts along the border where the executive branch has implemented enhanced immigration and drug enforcement initiatives. So, I mean, describe for us a little bit how this workload has impacted the 5 border districts' operations, including their need for probation officers, district court staff, public defenders, and secure facilities, and obviously not the least of which are judicial vacancies, because having a judge with 1,200 cases under his or her jurisdiction is pretty tough for one person to handle.
Well, the growth has been, as you know, phenomenal on the southwest border, and we were very, very appreciative of the $20 million in supplemental funding we received to help with that and to help us keep a pace. Nationally, criminal filings grew 25% between 2000 and 2010, and that growth was fueled by what happened on the border. And as you noted, now 41% of all criminal cases are prosecuted in 5 of the 94 districts, those along the border. Criminal case filings in the District of Arizona in 2010 increased nearly 50%. Efforts like Operation Streamline, which is it provides an expedited method of handling these prosecutions, drives workload not in the court but also in the pretrial services offices, where workload increased 14%. The workload has put a big strain on federal defender organizations and panel attorneys. We've put additional magistrate judges there. The probation and pretrial staff has increased in the border states has increased by 11.4% over this time frame from 2008 compared to an increase of 3.3% for probation and pretrial services offices nationally. In district courts, I'm looking for my figure for the district courts and not finding the amount
Well,
of the increase in the Board
obviously,
of Courts.
the pressure
But
in
the
this
pressure is
particular-
across the board.
Yeah, across the board. So do you all, or in order to help meet the demand in the border districts, do you all reallocate existing resources in districts that have a smaller workload just to help assist those courts along the border?
Yes, Jim can address this in more detail because he's involved with what the executive committee does in actually in adopting and executing the financial plan. But yes, money is shifted around in terms of court allotments to send money to the areas of greatest need and not areas where the money is not so needed.
Director, you want to talk a little bit about it?
The only thing I would add is we also send judges to help in those districts that are overworked from districts where they are less worked, I guess, and have time available to volunteer in other overworked districts.
That's actually been a very, very significant thing for a number of years now with the border states. Senior judges from other parts of the country have gone there. I mean, they've helped each other out within those districts, but judges will go down and handle, say, okay, I'll take 100 sentencings for you, or which is a big thing, or whatever it is. And they've been assisted by their colleagues in places with less arduous caseloads.
We need more judges, I guess. See, we would have a better time in the House getting the judges through. Absolutely. But that's not our responsibility. Let's talk just for a minute a little about courthouse security. You know, I know that you all operate many courthouses around the country that don't meet current security standards. So are y'all working with the Marshal Service and with GSA to identify all of those facilities that don't meet your security standards?
We are, and as we've mentioned before, because of recognition that courthouse construction is going to be more difficult to obtain funding for, although the needs remain great in our priority list where we've asked for it. We have sort of separated out security risks from the formula, although it was always a part of new courthouse construction analysis. But we've separated out security needs and prioritized those, and we would encourage a similar priority list as we used to do with courthouse construction, still do with courthouse construction, but have one also just for security needs, where the security needs are greatest. And
So, but how do you address them without building a completely new courthouse?
well, there are alterations and repairs in some instances to existing court facilities that are adequate to address the security concerns that we have. We've found in many circumstances. So we're able to do for far less than we used to be able to do with regard to funding when we isolate the security needs, and it is a top priority.
So how much do you think, let's just say, hypothetically, that a pot of funds would be available within the GSA for courthouse security purposes. Have you identified how much money you think would be needed for 2012?
I don't know that we have a specific figure, overall figure for the security needs there. We think a relatively small investment of between $4 and $17 million per facility that we were asking for would be needed.
Well, what would be helpful for us is if you could more
Quantify
clarify a little bit in a tighter weigh how much you think you would need?
I may be off, okay, I think, and if so, the staff will tell me I just misremembered something, but I believe at some point during the last budget cycle, we were asked to suggest a figure, and I think we suggested something in the neighborhood of 25 million.
We did.
In order to give us a small, to start on several of these facilities, see how it goes, and then obviously over a period of years, we would try to address all the facilities. Is that right?
That's exactly right.
All right, well, why don't you go back and look at, what the past proposal,
Right.
and get that to us sooner rather than later, and let us just take a look. I mean, I'm not saying that it's something that we can do, but certainly if you give us an opportunity to see what the needs are, and then GSA would just use those funds for that purpose. That might be real helpful. And speaking of GSA, your budget request proposes nearly $1 billion in rental payments to GSA, including funding for an additional 538,000 square feet of space. Now, I know that y'all are trying to reduce your costs, your space costs, and this is really difficult as, new courthouses, I'm not on your new list, but as courthouses continue to come online. But I think that in a GAO study, they found that y'all were occupying what would be considered excess space. So we need to figure out how to fix this. And tell me what you all think the best means would be to reduce these space costs.
Well, we have gone about as best we can in reducing projected space needs, engaging in courtroom sharing where it makes sense with senior judges, for example, with magistrate judges, and we've completed a recent study with regard to bankruptcy judges where courtroom sharing makes sense. You mentioned the GAO study. We've taken a very hard look at that study, obviously, and find some very serious flaws in it. And I'll give you one example for that's utilized in that study to say that we overbuilt courthouses and that there are empty courtrooms in the new courthouses that we've built, and our projections were wrong. Well, in the GAO study, they singled out the new courthouse in Fresno, California, as an example where they went out. It's a brand new courthouse, beautiful courthouse, and they find empty courtrooms there. And they say, well, we overbuilt, we overprojected. Well, the fact is, the Fresno court is probably the most overworked court in the country. The average caseload per judge there is over 1,200 cases a year. 1,200 cases a year, 100 cases a month per judge. It's an impossible workload. And so we've requested new judgeships for that district in California from year after year after year. And we built, the new courthouse was built with GSA in anticipation that those judgeships would be filled to help with the overburdened court. So the GAO study is, in our view, very flawed. But rather than get into a discussion about that study, we have taken very seriously the state of the budget and where we can save costs, save rent, reduce space needs. And as I mentioned, we've done courtroom sharing just, as much as we possibly can. So that's one area where we're trying to save.
So did you go back to the GAO and point all of these things out, and they come back to you and say what?
Well, we didn't really get a very good response when we pointed out the shortcomings. We actually had a hearing on this, and I think our judges did a superb job of illustrating where the shortcomings in that study was. And I don't think they responded in any substantive way that satisfied us, certainly.
If you look at this, it obviously would not be good stewardship of the taxpayers' money to build a courthouse that only accommodates today's needs. You have to look into the future. But when we try to look into the future, we get into to this same point we get into with our caseload, which is that it's very hard to predict what's coming because it's not within our control. I mean, we handle what people bring to us. But in our efforts to look at our future judgeship needs, the number of senior judges we'll have, our workload, I think if anything, we've been guilty perhaps of too much optimism about the extent to which Congress was going to accommodate our judgeship needs. And we are now talking with GSA about a new planning process that would, among other things, perhaps inject less optimism into the.
We've revised our projections.
Right, thanks. Mr. Serrano?
Thank you. Let me ask you about one of my favorite subjects, which is the American territories. Now, we may have discussed this in the past. I spend a bit of time every so often, whenever a program or a bill comes up, reminding people that we have American citizens who live in the Northern Mariana Islands and Guam and Samoa and the Virgin Islands and Puerto Rico. And usually what happens with everything else is there's a formula that affects the 50 states, and then there are negotiations that take place about how to deal with the territories. And it's very sad in many ways how it's done. I would imagine that the federal judiciary and the federal courts are an overall situation that do not get into formulas, or do they? So what I want to know is, how are the territories treated? How is it determined? I assume each territory has the federal court system physically in place there. They don't have to go somewhere else. So how do you determine the judges? Is it based on population, or is there, pardon the expression or the word, politics in there as it is over here? And what it is over here is, let's be honest, if Puerto Rico had, this is not a pro-statehood statement, if any of the territories had 2 senators and members of Congress, the treatment would be different. But since they don't, the treatment is different.
It's basically the same formula we use within the 50 states. And what we have found actually recently is that when a court in one of the territories is overworked, and we are required to send judges from the 50 states to a territory to help relieve the burden in the territory, that's an enormous expense. And you talk about travel expenses, Madam Chair, this is one where we pushed to get a judgeship, a vacancy, or a judgeship created actually in one of the territories recently, and a judge put in place there to avoid the costs of having to send judges from the 50 states to help relieve the burden in the territory. So in one sense, they benefited more recently, and they don't always benefit, certainly, and I agree that there are sometimes distinctions made that are troublesome. But in a recent example, we actually were able to get a judgeship and a new appointment because of the costs involved in having to send judges from the 50 states to help relieve the burden. But basically, the answer is it's the same sort of formula that we use throughout the federal court system.
We have lots of, different formulas. I mean, we use one formula for assessing judgeship needs, other formulas for staffing needs, other formulas for determining how other resources are allocated to the courts. And I believe that the same formulas are used in the territory courts as are used in the 50 states.
That's good to hear. That's not the answer I get with 99% of the people who come from other places, other agencies. As you know, in past hearings, we have discussed the lack of diversity among law clerks. I understand that the federal judiciary has instituted a new program to help address this issue. What can you tell us about this effort? Also, if you could provide, for the record, a diversity breakdown of law clerks by race and gender for appellate and district judges for the last, say, 5 years.
We'll be happy to provide the statistical information, and, you know, you and I have talked about this before, and I've said, you know, we're working on it, but we are not where we need to be on this issue. The Committee on Judicial Resources is the committee of the conference that is charged with working on this issue, and it has an ad hoc subcommittee on diversity, and under the auspices of that subcommittee, there is a new pilot project with the Just the Beginning Foundation, in which minority students, economically disadvantaged law students, are placed as interns in federal judges' offices. And there are currently 37 students who will be interning in the pilot program, and I believe that the hope would be to grow that over the next several years. There are some outreach efforts where the administrative office staff has met with various congressional leaders, directors of the Congressional Black Caucus, the Hispanic Caucus, and the Asian Pacific American Caucus to discuss our minority recruitment and hiring efforts. I think one of your staff people, Representative Serrano, attended such a meeting. AO staff has talked with the National Latino Law Student Association. They're contacting, the subcommittee is sending correspondence to law school deans in an effort to recruit minority applicants, sending correspondence to hiring partners at the nation's top law firms, suggesting that some of their rising star minority lawyers might want to come back and clerk for a year before returning to the law firm. They're urging various external organizations to help us improve our opportunities to hire minority clerks. And then there's an effort that's ongoing to encourage chief judges to take into account diversity when appointing magistrate judges. So there are a number of things underway, but we've got a ways to go.
Yeah, and you know, one of the things that should always, we should remind ourselves of, and I know you know this, but I think for the record it has to be said, these issues are not about simply getting some folks into certain positions. It's about groups that traditionally have been left out to a certain extent, in many cases years ago to a full extent, and people who want to be part of the strength and the structure of the country and want to serve the country. You know, when a person says, I want to be in the federal court system and I want to work there, that's not a person who doesn't want to be part of this society. You know, I mean, so it's just the opposite. But we've had situations here which are very delicate to discuss, but we had Supreme Court justices who told us, well, we don't have diversity because we recruit for clerks from Harvard and Yale. And the answer was, well, recruit somebody else, somewhere else every so often. It's not just those two schools. And I'm glad that you said that that there's communication with law schools throughout the country to make it better.
I agree. I mean, the University of Missouri graduates are as good as Harvard or Yale, and it just annoys me more than you know.
Really?
Yes, it does.
I'm more than the Cardinals record right now?
I believe we did win last night.
We lost. Yankees lost last night. It was the manager's fault. That's what everybody's saying.
Don't take responsibility, right? Let me ask you all about your information technology request. And this is important just because, interestingly enough, we had a hearing with the head of the GSA Information Technology, Vivek Kundra, who is the CIO for OMB, and the GAO's person. And I mean, we do not have a great track record in this government on IT, and I can't begin to tell you how many, probably billions if you add it all up, of dollars have been spent, and it's just not been well spent whatsoever. But anyway, y'all are requesting $550 million. And So of that 550 million, how much is for developing new IT programs versus maintaining the existing systems?
I'm not sure I have information that's directly responsive to the 550 million figure, and will answer that question more directly. I do have information about the 396
Okay.
million that's requested for the Judiciary Information Technology Fund. And of that amount, it's broken down in a number of ways, but about almost $100 million of it, 99.7 million, is for systems and applications. And within that 100 million, 33.3 million is for development, 66.4 million for operations and maintenance. But I'm told that operations and maintenance can also include sometimes development activities such as repair of defects and some enhancements. And then, if you are interested, the rest of that 396 million goes to allotments to the courts, infrastructure and collaboration that support the national IT program, voice and data transmission services and telecommunications equipment, courtroom technologies in new and renovated buildings, and staff who provide IT development, management, and maintenance for the courts.
Okay.
And we have been spared the bad situation of having to fix stuff that was not done properly. We've had a process that thankfully has worked.
So you have confidence then that the judiciary does have the IT project and contract management staff to execute such a large IT program?
Yes, we have a planning process, but more important, and that includes both staff and judges through the conference committees and ultimately the judicial conference. But more importantly, I'm convinced through talking with some of the folks in the administrative office that one of the things that really makes it work and has made it work is the way we have staged and tested and managed the systems as they have been implemented. And we apparently have folks who have very significant project management skills who have really done a good job in helping us do this. So it appears, thankfully, that so far so good on that one.
So do you, before starting any kind of IT program, do y'all do cost-benefit analysis?
Oh yes, that's a part of the formal project management process, and it's also a part of the planning process. So, you know, it is taken into account along the way. And there's also something called identifying quantitative and qualitative tools and techniques to manage cost and mitigate risk.
Well, Mr. Serrano's I think, a true geek when it comes to IT, which is a compliment. He loves it all, so.
I also played a judge on Law and Order once.
I'm sorry, say that one more time?
I also played a judge on Law and Order once.
You did.
I had to do one scene 7 times because I kept stepping on the robe. It was very...
Obviously didn't.
Sam Waterston was
measure
in front of me, and you know, all these great actors, and I kept stepping on the robe.
How'd you get that gig?
They read in the Village Voice, they asked me, if you were not a member of Congress, what would you be doing? And I said, I'd love to either play center field for the Yankees or act and sing, but I have no talent. So they called up and they say, want to read a part? And I read a part. And so they sent me a strip and they said, there's only one problem. You're playing a Hispanic judge and there's only one problem with him. And I said, oh my God, he's not a drug dealing judge. No, he's very liberal. I said,
Perfect.
it was written for me. It's a great experience. Not that I pay attention, but it came out on DVD. It's this season 5, this 3, episode 1.
Should
Well,
we be writing?
You know.
I don't get any money, so it's okay.
Good evening, more question.
Just one.
Okay, please go ahead.
You might have answered this question, and if you did, you can either answer it a different way, or I'll just go read this transcript. But what is the impact of GSA's decision to include zero funding for new construction of courthouses?
Well, we're not happy about having our priority projects not included in GSA's request, and
Right.
obviously there's a pot of money that it has out of which it's requesting construction, and by whatever process they use, no courthouses were included, and obviously our position is we'd like to have our priority projects on a list somewhere.
Of
to
course,
be-
there is a courthouse
I
in
mean, they are
Hawaii,
on the
right?
list, but,
Yes, I believe there was a courthouse in Hawaii
Hawaii.
listed.
well,
But
interestingly, we learned after hearing that there were questions about that yesterday, that's not the courthouse part of that building. It has nothing to do with the courts. It is
You mean the president didn't get his way and put a courthouse back home?
It's a federal building and courthouse, and the project that is being proposed, we understand, is not related to the courthouse part of the structure, and what needs to be done in the courthouse part of the structure, I believe, has already been done.
Well, you were wonderful to give us that clarification.
Yes,
Thank
because
you
it
very
became a
much.
big issue yesterday.
Yeah, I mean,
big
we
issue.
did, we kind of got carried away.
I mean, we were saying,
Well,
well, it makes sense, the president's from Hawaii. Notice I got that in, that he was born in Hawaii, And
And I said we did believe that.
you did believe that. And the chairman of Appropriations in the Senate, so we figured Hawaii makes sense. Now you're telling us it's not.
Well,
a
we were
courthouse.
trying to figure out yesterday what this was we were supposed to be grateful for, and then we ascertained that
Came up empty.
Well, thank you very much. I mean, it's very helpful
Yes, thank you.
to us.
I would say that we have developed good working relationships with GSA, and I think they're under some pressures from OMB on what they submit, but we really would like to see our priority list for courthouse construction passed on through GSA.
Just one last question. The so-called mega cases, the Madoff type things, are those cases still having an impact on court resources?
Are you asking about bankruptcy cases that have been called mega cases?
Right. Was
Yeah,
it dealing with $100 million in assets or more, or a
Yes.
1,000 creditors?
Yes.
they do have an impact, but the handling of those cases is really, I think, quite a success story, because the courts and the judges that have had those cases have really rallied around and figured out ways to handle them, and they have done so. And I think it's really a tribute to the courts that have figured out how to handle those cases properly and with dispatch. And so, yes, they have an impact, but it's one that's seen generally within the budget of the bankruptcy courts, as opposed to something we are saying to you we need help with. We're doing fine on that.
By the way, one of my great moments in that Law and Order was telling the police they couldn't do that search
Did you
that
speak in
way.
Spanish or English?
Oh, it's all in English.
Well, you were playing a Hispanic judge, you said.
We speak English. I mean.
Well, I understand that you speak English, but
Yeah, no, I was dubbed for Latin America, but I could have done my own
you
dubbing.
should have done your own dubbing. You would have gotten more royalties.
No, I didn't get it.
Judge Gibbons and Mr. Duff, thank you very, very much. But, Mr. Duff, I want to tell you before I close the hearing, we are really very thrilled that you were kind enough to allow Karen Thomas to be a
Oh.
detailee for the subcommittee this year. She's doing a great job, seriously a great job, and I don't know what we would do without her.
Oh, that's very nice to hear.
So,
We're glad to be of help. I'm glad
and-
she's of help.
Well, thank you, and I'm certainly grateful, and I know I can speak for Mr. Serrano when I say that you have saved us, and she has more than met the expectations.
Well, that's great. It's good to hear, and we're grateful for the opportunity she's getting here.
Well,
And-
thank you.
And I don't want to make Congressman Serrano feel too bad. I will buy the DVD, but But my great uncle did play center field for the New York Yankees, so,
He did?
yes. Earl Combs. You wouldn't remember Earl.
Earl Combs, of
Wait,
course.
With the 27 Yankee, that
With the
great Yankee.
Murderers Row.
Murders Row. He's a leadoff hitter from Kentucky.
Yes.
See?
I'm surprised he hasn't worked that into his testimony at an earlier time.
You know you
You could
can.
tell I'm no longer chairman. Otherwise, he would have.
Thank you all so very much.
Thank you, Madam Chair. I agree with you about University of Missouri.